Okay, let's go on the record on cause number DC 1918915 Marriott International Inc. versus Goody Goody Liquor Inc. Council, make your appearances.
Monica Vaughn for Plaintiff Marriott.
Eugene Kim, defense counsel for Goody Goody Liquor Incorporated.
All right, let's go ahead and proceed.
Your Honor, we filed our traditional motion for summary judgment and no evidence for motion for summary judgment on this non-subscriber claim when the injury took place on December 9th, 2017. Goody Goody had delivered an order of Miller Lite beer that was ordered by the plaintiff Marriott, and the employees for Marriott were pulling the beer out of the boxes, getting it ready for service when one of them exploded and a shard of glass was lodged into the eye of the Marriott employee, Mr. Antonio Reyes. We filed a traditional motion for summary judgment arguing that we do not owe a duty to the employee of a seller or a buyer relying on the Wilhelm versus Flores case that was decided by the Texas Supreme Court. And I have that citation noted in our motion under footnote 21. And we're also arguing that there's no evidence to establish proximate cause. In this matter, the plaintiff Marriott has to have evidence to show cause by the defendant, or show some evidence of whatever actions we had in terms of causing this Miller Lite bottle to explode. And they've only alleged that we've stored these Miller Lite bottles at extreme temperatures, but there's no evidence to show at what temperatures these bottles were stored at. There's no evidence of what the weather was like that day. And there's no expert that's been designated by the plaintiff to provide a report to us in the court to show how, if anything, Goody Goody Liquor or its employees did anything wrong to cause this one Miller Lite bottle to allegedly explode and cause the injury to their employee. And we also cite in our motion Tax versus Houston Distribution Company, which is a case out of the Houston Court of Appeals, which is on point with this issue. And in that case, the plaintiff had filed a suit against the distributor of the Miller Lite, just like Goody Goody, and the court granted the distributor its motion for summary judgment, and the Court of Appeals out of Houston had affirmed the court's decision on granting the defendant its motion for summary judgment. So based on our traditional motion for summary judgment and no evidence motion for summary judgment, we believe that Goody Goody Liquor is entitled to summary judgment.
Response?
Yes, Your Honor. On behalf of Marriott, I first need to bring to the court's attention that the response was actually filed over the weekend. And so I had filed a motion for leave to allow the response to be filed and considered to bring to the court's attention. Inadvertently, the date of last Monday was missed, and it was picked up over the weekend when I was getting ready for what was going on today. And that's why it ended up being filed on Saturday.
Mr. Kim, what's your position on that?
Your Honor, the rules clearly state you have to file a response within 7 days. But even if the court had considered the response by the plaintiff, case law and the summary judgment evidence clearly shows that we're entitled to a summary judgment on this matter, Your Honor.
So, yeah, I mean, that isn't much good cause. I mean, what even is the standard for a late filing? Let's see.
From what I understand, Your Honor, it's a discretionary call with the court.
Let's see. Summary judgment. If you get out your newest O'Connor's, go to 7B 6.9.3 if you want to. Must establish good cause and no undue prejudice. So, Mr. Kim, it's kind of up to you. I haven't read the response, so I don't have any idea to know what their arguments are. It was filed so late. Do you want to? I mean, if I do grant her leave, I would give you additional time to file a reply.
I don't believe I'm in a position to allow for it, Your Honor. I'm not trying to be acrimonious at all in objecting to the late response. It's I just have to do what's in the best interest of my client, I believe. Having said that, we would have to formally object to the late response and request the court not consider the response filed by Plaintiff Marriott.
So let me ask you this. What is the prejudice to you, other than obviously I'm considering that, to allowing the late file? I mean, are you guys close to a trial setting or kind of what?
We are coming up on a trial setting, Your Honor, I believe in mid-February.
Right.
Yeah,
you're right.
In February.
I don't even see there was a response filed. There's nothing on the system. I don't see a response file. I don't see a request for leave. I don't see anything on the system. Why don't we do this? I'll just grant the summary judgment, and then if you want to file a motion to reconsider, you can. The fact that there's nothing on the system kind of, I don't really know what to do at this point. There's nothing I can even look at.
And the motion for leave was filed just probably about an hour and a half, 2 hours ago, Your Honor. And so it probably has not made its way to the system yet. That's what I can surmise of that.
Yeah. Okay. Let's see. Did you file an order? Yeah, you did. Let me go ahead and grant that. All right, anything else today, guys?
That's all for us, Your Honor.
Anything else by the plaintiffs?
No. No, Your Honor.
All right. I will go ahead and sign that right now. And again, if you want to file a motion to reconsider, you can, but
Yes, Your Honor.
we'll go from there. You guys have a great day.
Thank you, Judge.
too. May we be excused?
You may.
Thank you.
So advice for the interns here is that's not best practices. If you screw up that badly, that's a huge mistake, not filing a summary judgment. You should be a lot more, I don't know. She didn't seem like she really cared. You know what I mean? It was like, you made a huge mistake. You're really asking the court for some type of leniency, and she doesn't even seem to think, I don't know. All right, our next hearing is at what time is our next hearing? It's at 2 o'clock. We have a couple of hearings at 2 o'clock. All right.
You don't have any cancellations for this afternoon?
We have had some. One of the 4 o'clocks canceled. We still have a 4:15 minor prove up.
Was it the 5-star or the Luminant that canceled?
Luminant canceled. They wanted me to set it reset it to the Monday of Christmas, and I'm like, no, I'm not going to. You've already have this date set. You can. I'm not going to set it the Monday of Christmas. So.
Well, I haven't had it. I was going to tell you this morning, but we were so busy. So my little granddaughter came early this week.
Oh wow.
Yeah, so she's a tiny little thing, but she's okay.
Well, good. Did you
So,
what day did she come?
Saturday morning.
Wow, lots of babies, lots of grandbabies on the 6th and 8th.
So I was gonna. I'll be here this week, but I got a sub for next week. So, but what do we have this week? Do you know?
We have some trials tomorrow. I don't know what's going to go. We have some non-juries. And then on Friday, we have a hearing docket, but that's pretty much it.
Yeah, everybody's switching their schedules around. So I'm going to, I'll be here this week.
Okay.
And then I was looking at December the 8th. Do we have a trial? I just said, I have it circled as a trial.
Yeah.
You don't know who it is?
Let me see. We were going to have a big trial. That was the one that Julie Pettit has taken over. It was going to be the Versailles case. And remember, she has her wedding. So,
Okay.
So I moved it to next month.
Oh, okay.
But we may have other trials. I don't know.
Okay. Cool.
Well, congratulations.
Well, thank you. I'm excited. She's a little cutie.
It's awesome.
Mm-hmm. The sad thing is her dad's grandmother passed like that night. And so the baby was trying to get her on the same day, but so,
Aww.
yeah. So he's highly emotional. But anyway, I'll be back at, you said 2.
At 2 o'clock.
Okay. All righty.
All right, we'll see you back at 2.
All righty.
This is that proof up at 4:15 that we didn't get to the other day.
I
There
don't
was
think
one
so.
that they didn't show up on.
I don't think that's it. This is a different one. This is the one against Twin Peaks.
And it involves minors?
Yeah, I don't know the facts. Yeah, I don't know. Why is it called
Should be
biters?
interesting.
Yeah.
Unless they hired somebody that was under 18.
Let's hope not.
Wow.
Cookies are really good. Thank you so much.
You're welcome. You want some more?
I want some more. Should I have some more? Probably not.
Well, see, when you make me leave, because you're doing something in here, I gotta find something to do.
So make some cookies.
That's the price you pay. Huh? Uh-huh. Yeah, I just baked them. I didn't start them till y'all went to lunch.
Oh my gosh. You're a great cook.
I forgot to tell them I was here today.
Okay, I'll be right back. You like the cookie?
I like them. Keep that going, that's very nice.
Hello,
Good afternoon, Judge.
how are you guys?
Pretty good, pretty good.
Let's see, are you guys here for the phase 2 case?
No, Your Honor, I'm here for Discover versus Wisam Chaya. I don't know if I
Okay.
pronounced.
Your Honor, I'm here for phase 2.
Okay. So neither side do we have, it looks like a complete set, is that right?
I don't believe so, but for phase 2 at least.
I don't believe so either.
Well, are you expecting the other side to show up?
Your Honor, for phase 2, I believe it was the mediator who asked for this hearing.
Okay.
Other than that, I don't know what it's about?
For us, Your Honor, we noticed this Zoom hearing back on October 27th, so I don't know whether they'll show up or not.
Okay. We'll give them a few minutes. You guys have a good Thanksgiving.
Yes, Your Honor. Ate way too much.
Same here. How was your Thanksgiving?
It was good. It was good. I was sad I didn't get to see my dad. He was hesitant because of his age and health condition to have us come in, which was kind of sad. But other than that, it was good. Did you guys stay in town?
We did. I don't have family in town, but we just kind of hung out. I've got 2 little kids, and so we had a great time, spending lots of time together.
Well, that's good.
My wife and I visited family in San Antonio. It was particularly exciting because we announced our pregnancy, my wife's first pregnancy.
Oh, congratulations.
Thank you. Thank you. Thank you.
I have 20-year-old twins. You're about to embark on the most amazing experience of your life.
Oh, I have 6-year-old twins.
You do?
Yes. Just started kindergarten.
Oh my gosh. Are they boy, girl, or what are they?
2 girls.
2 girls. We have boy, girls. So are those your only kids?
Yes.
Yeah, I don't know how people have more kids after they have twins. It's
2 is enough. 2 at once is enough.
I call it extreme parenting. You just kind of go through everything once. So
Absolutely. Oh.
Juliet, who's my intern on here, knows my kids.
Okay.
They went to the same school for quite a while.
Oh, nice.
Well, it's 2:05. I don't know what to do about this mediator thing. I assume that he would show up. Was that Fred Lewis?
Yes, Your Honor. I never saw what he filed, so I don't really know. I mean, I've spoken with him, so I do get what it's about, but
What's it about?
he's having issues with opposing counsel.
Not wanting to mediate?
Mm-hmm. Not responding, that sort of thing.
Well, has that been worked out or no?
We do have mediation scheduled for the 3rd, which is this week. But the last time I spoke to him, he still wanted to have this hearing. So I'm not sure.
I don't know either.
Oh.
Well, let's take care of the summary judgment first. Go ahead and make your argument. Oh, oops. This is Judge Hoffman.
I have Fred Lewis on the call. He said he's having some computer technical difficulties. Did you want me to transfer him through?
Transfer him onto Zoom?
I'm trying to work with him to see if he can get it on Zoom on his phone, but he said he didn't know how to do that. So I didn't know if you wanted me to just put him through.
Okay. Ms. Turner, can you hear my coordinator?
I sure can.
I guess I'll go and put him through.
Okay, here he comes.
Mr. Lewis?
Yes.
Hey, so this is a little complicated. We have you on the phone and then the attorney for which side, Ms. Turner?
Phase 2.
For phase 2 is on the phone. And so, but the attorney for DCAT isn't on the phone. So I guess kind of tell us what's going on. I think she can hear you, but you might have to speak up a little bit.
All right. Judge, basically, I thought we had continued this thing. My computer crashed, and Apple will not have it available to me until later this evening, around 6 or 7.
Okay.
But the basic issue was, and I would prefer putting this off to see how the other side reacts and performs in the mediation that tentatively is scheduled for December 3rd at 9 a.m. However, getting my computer back has been a problem because it's extremely difficult to get into Apple, period. It's hell.
Okay. Ms. Turner,
But,
go
I
ahead.
have no problem with the plaintiff counsel, none at all.
Okay.
The issue, I want to make sure that the court's order is taken seriously by the other side. And that's basically my issue, because I was told in writing that one of the attorneys on the other side was in fact the lead counsel. And this isn't the first time that I or others may have had problems with DCAT's counsel.
Yeah, wouldn't be the first time.
I know, and your court's not the first one either. There's another one. I don't know how many, but there's numerous cases down in the 134th. So, but I want to give them a chance to fully comply with your order.
Okay.
And if they fully comply with the order, I'll have no problem at all with sending a letter in requesting that no further hearing would be required. But right now, my biggest handicap is when that computer crashed on me. I mean, it just went boom. So that's the only problem. And I thought we
no worries, no worries. Ms. Turner, did you want to say anything?
I don't have anything, Your Honor.
Okay. Well, Mr. Lewis, just go ahead and reschedule whenever you get your computer up if you still need to, and hopefully we can get this all worked out.
Right. I think we can. However, I will say this, Judge, on Mrs. Turner's side, on the plaintiff's counsel, their cooperation could not be better.
Good, good.
Okay.
Well, she's smiling real big right now, so that's good. So
I'm serious, Judge. You've known me for several years.
I have.
And, you know, I'm just a straight shooter, no nonsense. And, you know, we got enough problems getting things worked out than someone coming up sending you a bald-faced, well, lie.
Well, that's never good. That's never good.
Okay. All right.
Well, Mr. Lewis, have a happy holidays. We'll see you soon, okay?
All right. You take care, Judge.
All right.
Thank you, Mr. Turner.
Bye-bye.
Bye.
Okay. Well, hopefully it all gets worked out, Ms. Turner. I apologize for the inconvenience. You guys have a great week, okay? And good luck with those twins.
Thank you.
Bye-bye. All right, Mr. Rayford.
Yes, Your Honor.
Oops. Oh, we're still on YouTube. I didn't realize that. Okay, let's keep going.
Mhm.
Mr. Rayford.
All right, Your Honor, this is a breach of contract case. Defendant opened a credit card account with plaintiff, used the card, ran out the balance, stopped making payments, and the account went into default. Plaintiff is asking for damages in the amount of $10,781.66.
And there was no response filed, correct?
No, Your Honor, no response was filed.
Court will grant summary judgment as requested.
Thank you, Your Honor. I recently, an hour before the hearing, filed a revised order because there was a payment made since we filed the petition, but it has updated amounts.
Oh, okay. Can you grab Rhonda and have her bring me that order back that I just gave her?
Okay.
So did you email that to Rhonda?
I had our list assistant e-file it.
Go ahead and have her email it to Rhonda, and we'll go. I'd sign the old order, and I'll go ahead and sign the new order.
All right, will do, Your Honor.
All right, Rhonda's my court coordinator.
I'll